Of all the interactions we have in a day, more and more now happen with artificial intelligence. Whether it's quick chats that help with recipes, relationship advice, or venting about a bad day. People type intimate details, ask awkward questions, and sometimes admit things they wouldn't say out loud. And that is how we arrived at this. Your ChatGPT conversations can and will be used against you in a court of law. Over the last few years, AI moved from a niche research topic into a tool millions of people use every day. That shift accelerated after the public launch of ChatGPT in late 2022, which helped push generative AI into mainstream awareness and drove a huge surge in consumer and business experimentation. At the same time, organizations rapidly adopted AI tools. Surveys show a major uptick in generative AI use across companies as businesses race to put the technology into workflow and products. These days, lots of people treat AI chatbots like private diaries. We pour out intimate details, ask for relationship advice, admit mistakes, or even brainstorm risky ideas. This is Sam Altman, the CEO of OpenAI, in a recent appearance on the Theo Von podcast, where he talks about ChatGPT and the privacy around it.
People talk about the most personal shit in their lives to ChatGPT. It's, people use it, young people especially, use it as a therapist, a life coach, having these relationship problems. What should I do?
These tools are at their core record-keeping systems run by companies. And courts can, when they find these records relevant, order these companies to preserve and produce the chat logs. Here's the thing. Conversations with an AI chatbot are not the same as private conversations with a licensed professional. When you talk to a lawyer or a therapist, you may be covered by rules like attorney-client privilege or doctor-patient confidentiality. Talk to a bot, on the other hand, and you don't get that protection. That means intimate confessions, plans, or incriminating details you share with a chatbot can be subpoenaed as evidence, just like emails or text messages. This is because there currently isn't any law that can protect conversations you have with ChatGPT. On the same podcast, Sam Altman also had this to say.
And right now, if you talk to a therapist or a lawyer or a doctor about those problems, there's legal privilege for it. There's doctor-patient confidentiality, there's legal confidentiality, whatever. And we haven't figured that out yet for when you talk to ChatGPT.
That means your chat could literally become evidence against you, because chat records can show intent, knowledge, timing, or admission, exactly the facts courts care about. When you type into ChatGPT or any chatbot, those messages go to the servers. By default, these conversations are stored. If you later delete a chat, OpenAI's own policy, for example, says deleted chats are removed within 30 days unless a court orders otherwise. With the use of a subpoena, a judge or a party can require the company to hand over those records. So deleting it or turning off history are not reliable shields. Deletion often removes only the copy you see. Companies can have backups, server logs, or archived outputs that courts can still demand. So, what about privilege? Could someone argue that a private conversation with an AI deserves protection? There's growing debates. Some people are calling for an AI privilege. But privilege historically depends on defined relationship and public policy reasons for protection. Attorney-client privilege, for example, protects candid communication between a client and a licensed attorney because the legal system values frank legal advice. Extending that same immunity to chats with an AI would require new laws or major court decisions. At present, the safe assumption is chatbots do not create legal privilege. Courts aren't inventing new powers to reach AI. They're using familiar discovery tools that have always applied to records. What is new is the format and the speed at which people are placing intimate and incriminating data into those systems. When emails first appeared, people thought they were too casual to be used in court. Nobody imagined screenshots from WhatsApp or SMS would one day be key pieces of evidence. It is the same pattern repeating with AI. ChatGPT and similar tools are just another form of digital communication, written, stored, and traceable. So as soon as courts realize those conversations can show intent, knowledge, or state of mind, they start treating them just like emails and text messages. In the end, AI chatbots are useful and safe for countless tasks: brainstorming, learning, drafting non-sensitive content, and prototyping. The point is not to banish AI from your life. It's to be deliberate about what you put into it. If something is intimate, legally sensitive, or could be incriminating, don't type it into a general-purpose chatbot. Consult professionals when you need privileged advice. Bottom line, treat AI chatbots conversations like records, not secrets. They can be preserved, subpoenaed, and produced. Until laws create a new protection for certain AI, the safest posture is simple. Keep private things off general-purpose chatbots, and assume anything you type could someday be part of. Right now, your ChatGPT chats are essentially data that can be used against you in court. So, next time you're tempted to spill your secrets to a chatbot, be mindful of what you share. Think of ChatGPT more like a public square than a private confidant. If you need real legal or medical help, stick with a licensed professional. That way, your words stay protected by the rules of privilege. Thank you for watching. If you like this video, please subscribe, like, and leave a comment.